Hello viewers, greetings of the day. I am Drishti Jain, 4th year BLLB student from Symbiosis Law School, Hyderabad, and I'm currently interning at ubAdvocate under the guidance of Advocate Jeevan Prakash sir. In today's video, I will be discussing the Criminal Procedure Identification Bill 2022. Let's start. The bill was introduced in Lok Sabha on March 28, 2022 and passed on April 4, 2022. The bill seeks to amend the Identification of Prisoners Act 1920, an act passed during British period that empowers the police officers to collect certain identifiable information of persons, including convicts and arrested persons. The term identifiable information means any information that helps in determining identity of an individual. The object of the bill is to provide legal sanctions to taking appropriate body measures and second, preserving the records of such information. The bill seeks to amend the provisions of the Act by widening the ambit of three major provisions that are first, the type of data to be collected, second, the individuals from whom such data is to be gathered, and third, the authority that may authorize such collection. Now let us see each of these provisions. First, data to be collected. Previously, under the Act, only fingerprints and footprints were considered as measurements under the definition of Section 2D. However, this has been amended by the Act to include palm print, iris and retina scan, physical and biological samples such as hair samples, blood samples, swabs, etc. Behavioral attributes including signature and writing, etc. Second, persons whose data can be collected. The 1920 Act provides that any person convicted or arrested for offences punishable with rigorous imprisonment of 1 year or more, or persons ordered to give security for good behavior or maintaining peace. However, the bill seeks to amend this provision to include any person convicted or arrested for any offense. Second, person detained under the preventive detention laws. However, biological samples may be taken compulsorily only from persons arrested for either the offenses against a woman or a child, or if the offenses carries a minimum of 7 years of imprisonment. Previously, magistrate may order in other cases collection from any arrested person to aid in criminal investigation. However, this provision has changed to include any person and not just an arrested person. Third, individual who may seek or collect the data or authorize the collection of data. Firstly, let us understand who can collect the data. Previously, under the 1920 Act, investigating officer, officer in charge of a police station, or of rank sub-inspector or above were entitled to collect such data. However, in the present bill, officer in charge of a police station or of rank head constable or above, additionally, a head warder of a prison can also collect data. Coming to the part who can authorize the collection of such data. Previously, it was only the magistrate who was empowered to authorize collection of data. However, under the bill, metropolitan magistrate or judicial magistrate of first class are entitled to authorize the collection of data, and in cases where a person is required to maintain good behavior or peace, the executive magistrate can also authorize collection of such data. Let's discuss storage of the data. The bill empowers the National Crime Record Bureau NCRB to collect, store and preserve the record, and also it is responsible for sharing, destruction and disposal of record. Any information recorded under this act shall be preserved for 75. Punishment for refusal. A person cannot refuse to provide data as it will be considered as preventing a public official from performing his duties both under the 1920 Act and the 2022 bill. It will be an offense under section 186 of the IPC, which is punishable by 3-month jail term or fine up to 500 rupees or both. The bill also empowers police officers or prison officers to take measurements of any person who resists or refuses to give measurements. Now let us discuss the issues and challenges. The bill has been criticized by many within the House and outside the House for being violative of right to privacy and Article 14 of the Indian Constitution. On reading of the bill, one can understand that a wide powers has been given to police officers and prison officers that may result in misuse and breach of privacy. The lack of provisions relating to storage and usage of the data recorded and the necessary standards are not met, which might lead to breach of privacy and misuse of such information. There is also an excess of delegation of powers to authorities in the bill, and some unambiguous powers and provisions are included which might cause misuse in future.